Thank you, David. Good morning, everyone. I'm going to speak briefly on my usual theme, the challenges involved in enforcing European Community environmental law at national level. And as usual, those of you who know me, as a case study, I've selected the EIA Directive for its obvious relevance to anybody who is interested or concerned about environmental protection. But the focus of today's paper, which is a short paper, is very narrow. I'm going to zone in straight away on one particular aspect of the directive, and that is the access to justice provisions, which, as many of you in this room will know, are found in Article 10A of the directive. Now, there's a paper included in your pack. I think I'm somewhere in the middle, and the pages don't run consecutively, so if you could quickly and efficiently move to the text just to have it to hand. I'll be picking through it fairly quickly, not at all just reading out every detail, but the references are there for those who want to follow up later themselves. So the one aspect of Article 10A which has generated a substantial amount of litigation so far is the requirement that the review procedure, if you're reviewing a decision of a public authority that involves the EIA Directive, it's clear from Article 10A that the review procedure must not be prohibitively expensive. That's the actual language used. It sounds deceptively simple, but the reality on the ground, as most people in this room will know, is far from simple. And the law is struggling at national level to come to terms with what Article 10A might mean for the national system. Litigants, lawyers, judges, everyone is having difficulty, and it's very hard to pinpoint the relevant legal principles. So that's the task I've set for us, and I say us today because I'll just throw out a few ideas, and hopefully then during the discussion we'll be able to unpick Article 10A and get different views. So, turning to the actual paper, if I could ask you to skip to paragraph 3, just to bring everybody up to speed. What is Article 10A? Where does it come from? It comes from a directive, 2003-35, which is colloquially known as the Public Participation Directive. So we've only had Article 10A since 2003. It's a relatively recent provision. Delving further back, it has its origins in the Aarhus Convention, which again, many of you will be aware of. The Aarhus Convention has inspired, if you like, Article 10A. Turning quickly to the next page to paragraph 4, I'm just jumping through the background. Ireland, as you know, is the only member state of the European Union that to date has not ratified the Aarhus Convention. That's obviously an embarrassment, and only time will tell how quickly, if at all, Ireland will remedy that particular situation. But the Convention is still relevant in Ireland for the very simple reason that Ireland is a member state of the European Union. The European Union is a party to the Convention, and the European Union has made directives which purport to implement various Aarhus obligations. And Ireland is clearly bound by those European directives. So we can't simply ignore Aarhus even though we've not ratified it. To be clear, the directive, including Article 10A, was supposed to have been transposed into Irish law, as was the case in all the member states, by the 25th of June 2005. So we're coming up close now to the 4th anniversary for transposition. And as you'll see presently, it's quite shocking how little clarity has emerged in the meantime. Article 10A is a fairly cryptic provision. It's the sort of thing that every time you look at it, you notice something different, and you wonder how you didn't notice it the first time, but it's something that evolves very, very quickly in terms of trying to identify what it really means. I've set it out verbatim on the handout in bold print, just so people can, if they want to in their own time, have a look at it. But the basic obligation is that member states must provide access to a review procedure where certain people can challenge the substantive and procedural legality of decisions involving EIA. So it mandates access to a particular type of review procedure, and that is often loosely and somewhat inaccurately described as access to justice, and we can come back to that point. I'm being very selective, as I said. I'm putting one particular piece out of Article 10A, and it's the sentence that says any such procedure, meaning the review procedure, and this is on page 3 of the paper, shall be fair, equitable, timely, and not prohibitively expensive. That is the actual wording. Article 10A, paragraph 5, middle of page 3. Fair, equitable, timely, and not prohibitively expensive. So the obvious question is, why on earth is this topic of interest, and why are we looking at it again this year? Many of you will have heard me speak on this topic before. The bottom line is litigation costs in this jurisdiction, as you know, are very high. There are a substantial number of cases now going back over the years where the courts have awarded costs against unsuccessful litigants in environmental and planning judicial review, and that these costs have often run into the hundreds of thousands of euro. That's the stark reality. So with costs potentially running into hundreds of thousands of euro, the obvious question is judicial review in this jurisdiction prohibitively expensive? That's cutting to the chase. That's the net issue. Is judicial review in this jurisdiction prohibitively expensive within the meaning of Article 10A? And in order to answer that question, and the answer isn't easy, we have to try to make up our minds as to what not prohibitively expensive actually means. And I pose that question in relatively simple terms at the top of page 4 of the paper. I'd ask you to turn to that if you wouldn't mind. Again, I'm running through it quickly, as I said. Top of page 4 of the paper. That reference, not prohibitively expensive, it's one of the most intriguing aspects. What does it mean? How do you measure it in practice? So in other words, turning it around, just how expensive is prohibitively expensive? So you have to interpret the language, and prohibitively seems to me to imply a fairly high threshold of cost. But again, even that simple statement is controversial. And the bottom line, as you see there, what impact, if at all, does this obligation have on our rules governing costs in judicial review where EIA is at issue? So very quickly we have to look at the Irish rules governing costs. And the position is that, generally speaking, costs follow the event. In other words, the loser usually has to pay. And that's a fairly stark rule. But the courts, as some of you will be aware, have a discretion. They can depart from the general rule. And I've set out the detail of that here on the paper. The court might, for example, decide not to make any order as to costs, so both sides or whoever's involved carry their own costs. Or, in some cases, particularly if it's what's loosely described as a public interest challenge, the court might take the view that even though the challenger, the litigant, the person bringing the action, even though they have lost, because the legal issues involved were so important generally, beyond the parameters of the particular challenge at issue, that the court should give some costs to one of the losing parties. In other words, turning the rule a little bit on its head. But the bottom line there is the courts have a discretion, and it's up to the courts to determine where the costs will fall. But the reality is clear that there are many cases where they have awarded substantial costs against unsuccessful environmental litigants. And the obvious issue then is, does that practice deter people from bringing litigation in the first place? Because if it does, it means the setup is prohibitively expensive. And if that is the case, it means that Ireland is in fact in breach of Article 10A, because it's not, it would seem, fulfilling that particular obligation. Now, you could talk forever about the cases on costs in general terms in Ireland. I've pulled out two, you see them there in paragraph 7 of the paper, to make a very simple point, which is public interest litigation is fairly underdeveloped in this jurisdiction in the environmental context. Things like protective costs orders, which in my view have considerable potential, that's not really been developed to any great degree in this jurisdiction. And the Friends of the Curragh case, which is mentioned there, is one example of that scenario. But more worrying, I think, is a Supreme Court decision there done in the Minister for the Environment. This is one of the many actions involving Carrick Mines. I call it Dunn number 4 for short, because there are a lot of Dunn cases, as many of you will know. But essentially in that case, the Supreme Court, I think, took a very narrow view of what is a public interest environmental challenge. They essentially concluded that the Carrick Mines litigation, which involved massive constitutional law issues, incredibly significant, in my view, European law issues, wasn't or didn't qualify as a public interest challenge because it wasn't exceptional or it wasn't special enough to meet this ridiculously high threshold that the Supreme Court, in my view, has set. So I'd throw that out for you to consider. But just moving on, The bottom line at the moment appears to be that apart from bringing in special generous locus standi rules for certain environmental NGOs, Ireland has not done anything else to implement, or sorry, I should be careful here, Ireland has not done anything else to transpose Article 10A. In other words, the Irish authorities, insofar as I understand it, and I'm open to correction on this, take the view that the existence of the judicial review procedure and everything that comes with it, the existence of that system is sufficient to meet the requirements of Article 10A. That, putting it simply, very simply in fact, is the view put forward. Now, the European Commission, as many of you will know, have, if you like, challenged Ireland's approach to Article 10A. They've brought Ireland, you'll see there, it's the top of page 5, paragraph 8. The Commission has brought Ireland before the European Court of Justice. And again, generalising and simplifying, the Commission alleges that Ireland has failed to transpose Article 10A fully. There's a lot involved in this particular set of proceedings, but that's one issue, that Ireland has failed to fully transpose Article 10A. That litigation is ongoing at the moment. We have an opinion from the Advocate General of the European Court of Justice where she has given her view as to how this litigation should be resolved. I'll talk about that in a minute, but just to be clear, the Advocate General's opinion is not binding on the court, so we have to wait and see how the Court of Justice will rule. But already the Advocate General's opinion has been picked up on by the Court of Appeal in England, for example, and it has caused quite a stir, I know for a fact, right across the European Union. The Irish litigation, case C42707, Commission in Ireland. There are a lot of Commission in Ireland environmental cases, so we need to give it its identifying number, 42707. This is the first case, insofar as I understand it, where the Court of Justice has been called upon to look at Article 10A. Look at it in a very limited way, unfortunately, but to look at it for the first time. So we're in the spotlight to hijack, I think, the title of Margaret's paper. There's very much a focus on Ireland. Now, very quickly, because as I said, I just want to throw out some issues. The detail is in the paper. There have been a number of High Court cases in Ireland so far where the High Court judges have struggled to figure out what Article 10A means and what implications it might have on the issue of costs in judicial review proceedings in EIA cases. Friends of the Curragh was the first fairly disappointing decision where Kelly essentially said, well, it's not clear what it means. It could mean court fees or it could mean legal costs. It's not clear, so I can't apply it, but just raised some very important issues. The most significant decision so far, really, and the one we spoke about a lot at this event last year, is Sweetman and Bord Planola number 1. Again, there's beginning to become a 1, 2, etc. there too, but number 1, this I think was a very good judgment from Clark in a number of respects. Clark was clear that whatever you feel about Article 10A, you must look at it in the light of the Aarhus Convention. So again, even though the Convention hasn't been ratified by Ireland, it clearly is having an impact in the Irish High Court. To cut a long story short, Judge Clark felt that Article 10A does not prevent the High Court from awarding reasonable costs against an unsuccessful litigant. That there's nothing to stop the High Court awarding reasonable costs against the unsuccessful litigant. That was his view. The question then, of course, which remains unanswered, what do you mean by reasonable costs? Like, how do you measure that? And that is wide open, but Sweetman is incredibly significant. Pressing on then, there have been some other decisions, key now to update from last year. Kavanagh in Ireland number 2, page 6, is quite worrying. This is a decision here of Mr. Justice Smith, where he essentially took the view that, again, if you interpret Article 10A literally, he said, well, that's going to be a cranks charter, and you'll have endless, frivolous, vexatious litigation. And those are his actual words. They're there in bold, a cranks charter. And his conclusion was, and it's the last, if you like, paragraph of the extract from his judgment there on page 6, which starts, in my opinion. In my opinion, the Aarhus Convention is concerned to ensure that the cost of entry into the court, in other words, court fees, just to get your leg in the door, that really is what the Convention in Article 10A is about. And even if it does cover costs, legal costs, which he doubts, sure, there's the taxation system, and that will ensure, in any event, that costs are not prohibitively expensive. So again, in my view, that was a fairly disappointing decision by any standards. And moving on, well, just to point out too, in paragraph 16, his approach is directly contradictory to what Frank Clark had done in Sweetman. So the High Court, obviously at odds within itself there about the correct interpretation. Just to note, Kenny there, which is a 2008 decision, where Frank Clark, if you like, revisited his Sweetman ruling and clarified a number of aspects which some of you might find of interest, and I've just set out the relevant provisions on the handout. But I just want to bring you quickly, and almost coming to the end of what I want to say, the Advocate General's opinion. In other words, the Irish High Court hasn't made up its mind, except for the Sweetman case, really, what 10A means. What does the Court of Justice feel about it? And what we have is the Advocate General's opinion. It came in January, so it's still quite new. Her opinion isn't binding, but I've set out in the paper the relevant paragraphs where she looked at the costs issue. Now, there are some very technical issues, unfortunately, involved in this particular set of proceedings that the Commission has brought against Ireland. It's very hard to explain, but I'll do my best. The Commission was arguing that Ireland hadn't transposed Article 10A at all, that it had done nothing. There were no transposition measures in place in Irish law. And there's another, if you like, add-on, which is, well, even if you had transposition measures in place, are they adequate? So, to cut a long story short, the Commission in Ireland proceedings, it seems, are limited to a very narrow point, whether or not Ireland has actually transposed, in other words, put in place some measures that attempt to give effect to Article 10A. The quality of those measures, it seems, may have to be argued in a subsequent set of proceedings. In other words, there's a very technical point about the scope of the proceedings in this particular case, which I try to explain to some degree there on the paper, but it's very narrow, and we can't expect too much to come out of this litigation. We just have to wait and see. But the Advocate General took a fairly robust view of Article 10A, and I've set out the relevant provisions on page 9 of the paper. She disagreed with what Judge Smith had said in Kavanagh. She says the ban on prohibitively expensive procedures covers all legal costs. So in her view, it does cover the costs of litigation. But Article 10A doesn't say that you can't award costs. And these are very important conclusions, because if the court follows her view, they may not, but if they do, this will give us some clarity. So you see there on page 9, just the extract from her opinion, there's no absolute ban on costs. Costs can be awarded up to a certain level. And she acknowledges in Ireland what you've got is you've got a judicial discretion. The judges can decide in their discretion to not award costs against an unsuccessful litigant in a particular case. But she concludes just because they have a discretion, well, that doesn't seem to be enough to really give effect to Article 10A. And I'm generalising now with the danger of inaccuracy, but the accurate bit is on the paper, but just again trying to give you an impression. So her opinion is very significant, and it remains to be seen how the Court of Justice will deal with these issues. But she is taking a robust approach and trying to give some real meaning and meat to Article 10A, which should assist the Irish courts down the line. The final thing I want to deal with is a recent Court of Appeal decision in a case called Morgan and Baker. It's there on page 10. Where the Court of Appeal, facing a similar challenge obviously to the Irish courts, say what does Article 10A mean? They're in a similar enough position. They have judicial review, there is a judicial discretion on costs. But in fairness to them, the Court of Appeal in Morgan attempted, as they put it, to draw the threads together and focused very much on the not prohibitively expensive requirement, and focused as well on the Irish decision there from the Advocate General's opinion in the Irish litigation. And what they say is there's the judicial discretion, but again it might not be enough. Something more might need to be put in place to ensure that judicial review law and practice actually takes account of the Article 10A obligation. And they take a very similar approach to that of Judge Clark and Sweetman, saying, well, when we're looking to apply Article 10A, us judges in our discretion, we must have regard to the Aarhus Convention. And that seems to me to be a fairly positive nod in the direction of a robust approach. But again, only time will tell. So the short conclusion is, well, what is Article 10A? Does it mean business as usual, which it seems to a degree, or is it in reality, or will it prove to be a crank's charter? I think the answer probably lies someplace in the middle. But what's so worrying is that 4 years almost since we were supposed to put measures in place, nobody still seems to know what Article 10A means. And the best we can do is to hope that the Court of Justice will provide some guidance when it rules on this. And there is, it appears, no clear indication of when the Court of Justice will rule in the Irish case that I mentioned to you. It's possible that an Irish court might refer the Article 10A question, like what does it mean, to the European Court of Justice on a preliminary reference, but that has not happened to date, but it might be a possibility in future litigation. So those are just some issues for you to think about. I have to unfortunately run out now to try and make some administrative arrangements, but I'll be back shortly and we'll keep you posted about the Minister's arrival. Things might be subject to change, hopefully not, but we play it by ear. So I thank you for your attention and I look forward to your questions later. Please excuse me. Thank you.